Oh, fair play. Samantha Terry was here earlier on at 1:04 p.m. Thank you, Sam. If you ever see this, put your DNA on the like button delivered. Thank you, Sam. And as you're actually coming in, welcome from Sarah P. Let me just get this sorted for the stream. But what a bitch. Right, see you later, Erin. Catch you later, Erin. Take care. Hola! Right, we've only got a little bit left. I'm finishing this tonight. Guys. I'm not messing about with this now. We're finishing this tonight. Because tonight is the night when two become one. Need somebody like I never needed love before. Ba-dum-ba, da-da-da-da-da-da-da-da-da-da-da. No worries, Nunia. Catch you later. Look at Erin, such a nosy bitch. She can't leave. She needs to know everything. Where's your mod, Nunia? Right, let me just share this. We're doing this. Then we'll finish then. You come and go. She comes and goes. BGZM, do who the hell that is. She comes and goes. This is a song Vernon. She comes and goes. Come on, come on, come on, come on, come on, chameleon. Here we go. BGZM. Don't know who that is. Right, are we ready? Are we steady? Let's go, go, go.
All right, so we're going to go on the record. Let me know when you're ready, Diana.
Just 1 second.
Okay. Yeah.
I was gonna leave sound test for a little bit after that here. Let's go ahead and do it just as we can. After on the same day.
Okay. Sure.
What was it about? You know what I mean? Huh?
All right. All right, everyone, please make sure your phones are silent or on off.
Okay, we're good, man.
All right, court is calling 2022 CR 9807, State of Texas versus Vernon King.
Hang on. Oh, Pepper Ann, hello back. Okay, I think I can stay for this one after reading further into the chat. And the other one is actually nice to see people having their own opinions. Everyone has their own opinions on ours, and everyone's respectful. And trust me, you might not agree with everybody, but everyone is respectful. Gets heated sometimes, but not really. It is a wonderful chat, and it generally was a bit divided, but everyone debated respectfully, and I appreciate what you've been through. Some others have been on the other side as well, so we just try to be respectful to each other as much as possible. But welcome, man. I'm glad that you're here. Don't listen to Perry. That's all we ask. We don't listen to him, and then he became. I'm joking, but no, welcome. Please, if you haven't done so, guys, anyone here who hasn't subscribed, please subscribe and make sure you like the stream. I've not checked yet if people have or not, but yeah, lovely to have you, Anne. Where are you from, Anne? Are you from the USA or are you from the UK? Where are you from?
King Dixon, can I have parties announced for the record for the state?
Jason Gary, on. Daniel Escobar, the state.
Adam Hood for the defendant.
George Schaefer, Your Honor.
Yes. And you're Mr. King? Mr. Dixon, I'm sorry. Thank you. All right, so outside the presence of the jury, we're going to have a hearing, Mr. Dixon, with regards to a statement that you're alleged to have been given to see whether or not it's admissible. Do you understand?
Like a couple of directly play back the same thing too. Yeah. So we're having a hearing, it's a case called Denby Jackson, but we have it outside the presence of the jury. So the jury doesn't hear any of this and the judge gets to decide outside the presence whether or not it's admissible or inadmissible. Yeah.
All right. So state, are you prepared?
Yes, Your Honor.
All right, state, call your witness.
The state calls Detective Juan Espinoza.
If you'll have a seat, if you could raise your hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Excuse me.
Oh,
My name's
go ahead.
Detective Juan Espinosa.
All right, state.
Yes, Your Honor. I don't, are the speakers working? Or the,
Hello?
okay,
Yeah,
there,
they're working.
okay. Detective Espinoza, one, who do you work for?
San Antonio Police Department.
And how long have you worked there?
I've been on the department for 17 years.
And what are your current duties as a SAPD officer?
I'm currently a detective in the homicide unit.
And why you're here today is that a state of Texas versus Vernon Dixon. Did you have an opportunity to interview Vernon Dixon?
I did.
And do you recall what date that was?
Back in September of 2022.
And where did you interview Vernon Dixon at?
Bear County Jail.
And was he in custody at the time?
Yes, he was.
And before,
Okay, just on that note, because I know Jonathan's not here. Jonathan, I'm glad he's not here. There's a mix as well, and obviously for political reasons, there's a mix of people. Sometimes people say stuff in jest about political parties. We don't do political stuff here. I mean, we got one viewer who is a massive Donald Trump fan, but he does it, he's great with it. He does to wind people up. He doesn't, he won't wind you up or anything, but he's not here today. But I respect everyone's opinions, but we don't do politics. It divides the whole chat, and I just don't want that. So, yeah, as soon as you said that, I was like, Jonathan. Jonathan's lovely, lovely, lovely guy, but he's a staunch, Trump supporter, which is absolutely fine. There's other Trump supporters here. I'm sure there's Biden supporters. There's a lot, whatever. I don't care. I just want people to be themselves and not discuss any political stuff, because I've seen my chats get ruined in the past. It's happened twice now that chats have been ruined by people going political, and I just don't want to do that. There's enough things to talk about rather than being just political. That's all. And I'd say the same to everybody else as well. So anytime politics is involved, I'm like, oh no, we can all respect each other. So welcome again.
you interviewed him, did you read him his rights?
Yes,
Did
He
you
has, yeah.
inform him that he had a right to an attorney?
I did.
That he had a right to remain
Yeah,
silent?
that's true.
Yes,
And
Thank
that
you,
anything he said could be used against him?
correct.
And that he has a right to an attorney to be present prior and during any questioning?
Correct.
And that he has a right to an attorney to be appointed and advise him prior to and during any questioning?
Correct.
And he has a right to terminate the interview at any time?
Correct.
And at the time that you did interview the defendant in this case, Vernon Dixon, do you know if he had an attorney appointed to him?
I did
No,
not.
it's fine.
And did he inform?
I'm warning you, that's all, that it will come up. Do not worry, it will come up. Once you meet Jonathan, you will understand, but he means no harm in it at all. Just don't take the bait on it. Yeah. He will mention Trump at some point, so just don't take the bait on it, he's a lovely, lovely guy. Lovely, lovely guy, honestly. I would pre-warn him because my Discord's full of Trump stuff. No, don't worry. Honestly, I'm just pre-warning you. I just don't want you to be offended by others either. So it's all good. It's all good. It's all good, Anne.
Inform you whether he had an attorney or not?
He mentioned if you needed an attorney.
Yes.
And was that on the video, that?
I'm
you-
going to grab a coffee. I'll be back now. I'll be back.
And did he waive all those rights and decide to agree to an interview with you?
Yes,
And did he ever mention that he would like to talk to you?
yes,
And so after these rights were read to him and he was informed of them, did he proceed voluntarily with the interview?
he did.
And Your Honor, at this time, would you like me to enter the video at the time?
Yes.
Let me just. Oops. Detective, you can look at that video and tell, I'm sorry, that disc, and tell me, is that a disc that you've reviewed for this case?
It is.
And what is that, a video or a disc of?
It's an interview of Vernon Dixon.
And is it a fair and accurate copy of that interview?
It is.
And is there a portion of this that has been redacted?
There is.
And it's actually, the video is still running, but it's been muted, is that right?
That's correct.
And that's the indication of the defendant stating that he was an ex-Crip member,
Correct.
and that's a gang,
Correct.
but that has been muted out.
Correct.
Okay, but other than that, everything is fair and accurate, copy of the original interview.
It is.
And for these proceedings, Your Honor, the state would enter, well, I'm sorry, Judge, I didn't get it
That's-
marked.
That's okay.
I don't like putting stickers on here, Judge. Would you be okay if I wrote it on there?
And Judge, the defense isn't objecting. From personal experience, I've seen it where if there's a sticker,
Yeah.
it will rank in catastrophic action a reader. There's not much space that's in there.
All right, if you all have the sleeve and you can mark the sleeve.
Yeah.
Okay. And Judge, I know that state exhibit, I think we're on number 39. Or number 40, actually, because 39 was going to be a stipulation.
Yes,
So would you like me to mark it as state exhibit number 40?
that's fine.
What's 39 gonna be?
39 is a stipulation.
Stipulation.
Actually, I have it. Yeah, we have 38 is photos of the bullets.
Right.
Yeah, so yeah, we're good.
39, yeah.
The 39 is stipulations.
Oh, yeah. And so, Judge, for the record, the state is asking to enter state exhibit number 40 for these proceedings.
All right,
No objections, Your Honor.
all right, then state exhibit number 40 is admitted for purposes of this proceeding.
And Your Honor, at this time, I don't know if the court has had a chance to review it, or would you like me to go ahead and play
The court has reviewed the entirety of the DVD. Both the state and the defense tendered the DVD to the court to review during the break. And I have had a chance to review the entirety of the video, not the redacted video. So there's no need to play it.
Okay, Judge, thank you. And Judge, at this time, the state would pass the witness for this motion.
All right, and just for purposes of the record, defense, are you stipulating that state's exhibit number 40 is authentic?
Yes, Your Honor. We're stipulating as to the authenticity, not to the admissibility at this time.
All right. Do you have any questions?
Just a few. Detective Espinoza, were you the person that conducted the interview that we saw in the video?
I am.
All right, and did you conduct any other interviews other than that interview with Vernon Dixon that day?
No.
Okay. No further questions for purposes of this hearing, Your Honor.
All right, thank you. You may step down. The rule has been invoked. You are not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense. All right. And if you'll just remain in the courtroom. All right, the court will hear argument.
Yes, Your Honor. I think it's our motion, so we can proceed. I think we go first on it. So, Your Honor, I know the court's reviewed it. Approximately around the 4-minute mark, I believe it is on the video, but certainly then first 5 or 6 minutes. The Detective Espinoza, he asked Vernon, do you have an attorney, or admonishes him. The client at that time, Mr. Dixon, says, I have a lawyer and everything else. Our contention is this, I believe the detective was put on notice that there was a defense counsel appointed, that there was an attorney present. There certainly wasn't a significant lapse in time since Mr. Dixon was provided with counsel. We think that any questioning, any statement that may have been elicited from the defendant should have been done in presence of counsel, or at the very least, interview should have been stopped at that point until defense attorney, in that case myself, could have been notified and given the opportunity to be there. That didn't happen. And what happened after that, obviously, was a statement by Mr. Dixon to the detective. Our contention is that anything he said after the detective, Mr. Espinoza, was notified that there was a defense attorney on the case should be held inadmissible. In the alternative, if the court deems that it was a proper admonishment, and for purposes of this hearing under Jackson v. Dino or Dino v. Jackson, that the statement was properly admitted, we do have an objection as to two things. One, I believe, has already been redacted. That was a mention of prior gang activity, and the defense is satisfied that any mention of it is redacted in the form of the audio being muted. It's just about 10 seconds or so. And so we don't have any questions about that. However, what we do have issue with is there goes into statements about Mr. Dixon being caught in Kansas, obviously several states away after the fact. The defense would object to any statement or any reference to that being brought in, either through his own statement or being elicited by the state's office as form of testimony. And the reason why, Judge, I think it goes back to a 403 argument. I understand, I anticipate what the state argument is going to be. However, I believe that it creates an impermissible bias in the minds of the jury, saying this is somebody who ran from an offense, and it just, I believe it poisons the well, Judge. And I don't think it's proper to go into the fact that Vernon was arrested, whether he was arrested a mile away, a foot away, or 10,000 miles away. I'm not sure it's necessarily relevant to the merits of the case, Judge. He was in custody. Obviously, he's here standing trial. And I think any mention of the fact that he was arrested out of state, again, puts into the mind of the jury that this was somebody that was running, that has something to hide, and therefore, under Rule 403, would be more prejudicial than probative. And for that reason, Your Honor, respectfully, we would ask that it be admitted. And just one second.
All right. And so just so everyone can know, I believe his mother is in the courtroom. Yes. So I don't know if the state of the defense is going to have objections to her being in the courtroom and release her from the rule.
Judge, I've asked Adam to put into the record when he was appointed prior to the interview. I want that in the record.
Yes.
And for the purposes of Miss Pearl being here, Judge, the defense is not opposed to her being here. I certainly respect the rule if the state wishes her to step out.
Mexi.
Your Honor,
Mexi.
Get the punishment. I'm just giving you fair warning.
we'd be opposed at this particular point then, for her to be present then, if she possibly might be called during punishment phase, Your Honor.
All right, Ms. Barnes.
Yeah, no, yeah, I don't see you sometimes, Maxie, on weekends. But yeah, it's going on a fair bit now, weekends. Jesus, I'm getting tired now. That's awesome. Yeah, I don't know the guy. I don't know, never spoken. I spoke to him briefly on Twitter, but let's just see. Do you know what I mean? He's welcome to come, so we'll see. I've never really watched him, so.
I'm sorry, but you're
But I know that some of you Aaron Hack and you watch him, so.
not going to be allowed in the courtroom because the rule has been invoked, and they may be calling you later. Sorry for moving throughout the record, Dinah.
And Your Honor, sorry, on the record, I see that Cherie Lewis was with Pearl Barnes, and she's also a subpoenaed witness. So I think since the rule's been invoked, we would ask that she be outside the courtroom. It looks like she has been moved outside the courtroom, Your Honor.
All right. All right, you may continue your argument. Your co-counsel said he wanted to put in the record when you were appointed.
Yes, Your Honor. Based on my records, I was appointed to represent Mr. Dixon, Vernon Dixon, on August 15th, 2022, which was anterior to the date of this interview. And I believe that's even mentioned on the tape that he had an attorney. So, Judge, for all the reasons stated, again, we would object to any admissibility of the statement. And if the statement does come in, certainly as to the part which has been redacted about any former gang affiliation, but also to any reference of Mr. Dixon being caught outside the state of Texas, due to the fact that we believe it is more prejudicial than probative. And for those reasons, Your Honor, we'll pass it off to the state.
All right, and with regards to the redactions that have been made, then the court, since the defense is in agreement to the redactions of gang affiliation, there's no need for the court to make a ruling on that because it's been redacted.
Correct, Your Honor. At this point, it would just be admissibility of the statement itself. And then if it is admitted, then we would move on to any mention which require a little bit of further redactions as to any mention of Mr. Dixon being caught out of the state of Texas.
All right, thank you. Oh, and you all can remain seated when you do your argument. All right, Mr. Garahan.
Yes, Your Honor. In reference to the admissibility of the defendant's statement in this case, the state has proven with Detective Espinosa's testimony that the statement was given freely and voluntarily, and also that he waived his rights to have his attorney present. In fact, if you listen to that video, which I know this court has, he actually states that he wants to talk to them, and then his rights are read, and then he continues to speak with the detective assigned to this case. Also, throughout his interview, at least 2 other times that I recall, he does state that he's been wanting to talk to the detective about this case, and mentions of the reasons why he wants to talk to him. So, into the question of the admissibility of the statement, the state's position is that it is admissible because it is a freely and voluntarily waived his rights, the defendant did, and proceeded with the interview. To go to the other portions of defense counsel's I guess motion, of course, we've already agreed to the gang affiliation to be redacted, and it has been redacted. In mention of the defendant leaving the state to go to Kansas and was arrested in Kansas and brought back to Texas, the state's position is that that's just evidence of guilt. It's more probative rather than prejudicial, because it's probative, outweighs its prejudicialness, because the fact is, just like fleeing a scene, that could be used evidence of guilt against the accused in a case. This is where he's fleeing the scene, but not only flees the scene the day of, but then actually flees the city, actually the state of Texas. And that's indicated in this interview. If you look at its entirety, he mentions Kansas, and he says that he went to Kansas to get away from this area because he felt that to prove his innocence at some point. So the state's position is that the probative value of the defendant leaving the state of Texas to go to Kansas is more probative, and that's how the state's argument will rest, Your Honor.
All right, and defense, it's your motion, so you have final argument.
Your Honor, again, we would just urge, just re-urge, I think we already said it, but I believe the detective was aware that he had counsel present, and we believe that the statement was improperly taken with an attorney appointed, or certainly representation by counsel, and the person being in custody. I believe that the interview should have stopped at that point, and defense counsel should have been notified.
All right. And defense, of course, the court does have the same concerns that you have. However, I'm just bound by what the law says. So with that being stated, your objection to State's Exhibit number 40 will be overruled. With regards to mentioning of your client being found in Kansas or leaving to go to Kansas, the court has done a balancing test. The court is going to find that it's more probative than prejudicial. So with that being said, State's Exhibit number 40, your objections to that will be overruled.
Yes, sir. Your Honor, we respect the court's ruling. We just ask that you note our objection for the record.
Yes, thank you. All right, so what we will do is, deputies, if you can check to see if all the jurors are here. They're here? All right. Just 1 moment. Let me fill up my water. And then if you have is this your next witness?
Yes, it is.
If you have him take the witness stand. Yeah, you can line them up.
Mexi, it's a murder charge. Do you know what I mean? So yeah, I mean, yeah, I agree with you. I agree with you.
Figured as old as you're getting.
We've got this like closing arguments and verdict. I think that's it today. I'm going to finish it all, and people can rewatch it whenever they want. I'm not sure what to do tomorrow, if I'm going to go live or not. I might take a day off. I mean,
Oh, everyone, please be seated.
it's non-stop streaming at the minute, and I don't have a day off. I'm going to make videos.
Hey, okay. All righty.
Just have 1 second
Yes,
before we.
sure.
I just asked that.
And defense, if you all want to check with
Oh my God.
evidence.
Oh, that's-
Here he is. We were literally speaking about you. Literally speaking about you. You can see in here, I was telling people about you. And Emma and Sarah were like, we've got to take the piss out of him net tomorrow. Don't worry at all, Jonathan. You get better, my friend. But you have genuinely been missed. Genuinely been missed. So get yourself better as soon as possible so you can get back in chat properly. Send a love to Sherry as well. But yeah, no, I knew there was something wrong. Or you were out there shooting a buck somewhere. So you look after yourself, buddy. We want you back full steam ahead.
We're just trying to-
And I will give this to you right
This
now.
school's been quiet and everything's been quiet.
again, for religious purposes. Any of this, but
Wow, you go to the doctors. It must be serious.
Did everything that we did last week.
I was saying good things about you, Jonathan, but Emma and Sarah P were slagging you off. They weren't. They weren't. Just because you're ill, I can't take the piss out of you.
You know what? I already have it. I mean,
So, Anne, Pepper Ann, if you're still here, this is Jonathan. I was telling you all about. Such a lovely guy. Sending love, Jonathan. Love, love. It's a
State, are you all ready?
love.
just one brief second. Sorry,
Okay.
guys. Left the copies of this report upstairs.
Okay.
So
And defense, do you have a copy of that report?
Yeah.
I was actually thinking about one of them out.
It says prosecution guys,
Yes.
20 rows.
Yeah, and then there's one additional one from the 28th.
I have
You
that.
should have
Supplement. Yeah,
Yeah,
it's all
okay,
there.
okay, I just want to make sure you had it.
It was a short supplement.
Yes.
Yes, no, we got it.
Almost done.
Bloody hell,
No
John.
problem. The
Get sorted,
copier
mate.
is printer/copier is very slow.
Well, Nurse Sarah must have gone.
Yes,
I'm gonna talk to somebody real quick. It might be a potential witness.
sure,
So there is a rule. If it is, I just don't want to run afoul of anything.
sure.
Yeah, you look after yourself, mate. Jesus, you don't want to be.
And Mr. Schaefer, if you need to step outside with him, you can.
And I already stated you're detective.
Yes.
All right, for hearing.
Oh no, that's just crap. Where's Sarah P when you need her? Where's the nurse when you need her? Well, you said you were tossing, Emma got excited.
All right, everyone, please be seated. State, call your next witness.
Yes, Your Honor, the state false detective Juan Espinoza.
All right, you've previously been sworn in. If you'll state your name for the record, please.
My name's Juan Espinosa. I'm a detective.
All right, state.
Thank you, Judge. Detective Juan Espinoza. Can you please introduce yourself to the jury?
My name's Detective Juan Espinosa. I am a police officer with the Santa Maria Police Department. I've been there for approximately 17 years.
And you're ready.
Right, Mexi, Texi, and Emma, you got to keep this squad going then, because if Jonathan's ill, we need some people to keep it going. So Mexi and Emma, you two, you got to keep it going for Jonathan. You got to keep it going for Jonathan.
I already stated you're a detective, so please just tell the jury generally what your duties are as a detective for SAPD.
As a detective, I'm assigned to the homicide unit. My duties involved investigating homicides, suspicious deaths, suicides, and officer-involved shooting.
And I'm gonna go over it briefly, and if you can just explain, did you go through certain training that you had to, one, become a peace officer or a San Antonio police officer, and also any other type of training that you had to become a detective for SAPD?
So the training we had was as a police
See?
officer, peace officer training.
Emma's there, team player. Mexi's like, what? No. Who am I? Ah.
Training through the academy. Any other training, once we were
Thank you,
promoted to
Maxie.
detective, was a lot of it was on the job training, caseload management, shadowing other detectives that have experience, and that's where our training came from.
And you previously stated you've been 17 years on the SAPD force, is that correct?
Yes,
And I'm gonna go ahead and take you back to March 31st, 2022. Do you recall that date?
I do.
And why do you recall that date?
That's the date of the homicide involving Vontae Boyce.
And you said Avante Boyce, is that the name, victim or deceased in this case?
That's correct.
And did you subsequently charge somebody with his murder?
I did.
And who did you charge with that?
His name is Vernon Dixon.
And you see that individual in the courtroom here today?
I do.
Can you please just point him out and identify an article of clothing he's wearing?
He's to my right, sitting at the defense counsel table. Blue and white pinstripe shirt and blue jeans.
Thank you. Let the record reflect that he has, the detective has identified the defendant in this case. Now, let's talk about the investigation into this, this particular murder. What were your duties and what were you tasked with doing on this investigation?
This investigation initially began, there was a shooting at the East Park Meadows. At the time, the victim was still alive, so Detective Guevara, who's assigned to the aggravated assault side of the homicide unit, went down to the scene and started the investigation there.
Yeah, no, I'm sorry to not to cut you off, but you stated that it was an aggravated assault type case.
That's correct.
Why was it an aggravated assault case at that point?
Because at the time, the victim had not passed away.
And so in the aggravated assault case, the victim would still be alive.
That's correct.
And in particular, an aggravated assault with a deadly weapon. Is a firearm considered a deadly weapon?
It is.
And so would that also be I guess, a revolver, like pistol? Is that a deadly weapon?
Correct.
And initially, like you stated that aggravated assault detective was assigned to it.
That's
When were you assigned to it?
Shortly thereafter, I believe Detective Guevara made the scene. I think within minutes after arriving, he was informed that the victim had passed away. And then from there, I was notified.
And at that point, is that when, I guess, you're in the homicide division, is that when y'all take over the handling of the case?
That's correct.
And so were you assigned this case that particular day or that,
No, that day, that moment.
so March 31st, 2022?
Correct.
And then tell me, or tell the jury rather, what were your duties as in particularly to this case after you start handling it?
So my part that day, since I was in the office, we're usually assigned another detective that works homicide as well. And Detective Platt was we call our wing. She made the scene and assisted Detective Guevara at the scene. And then she informed me that we would have one witness coming down to the homicide.
And so you stated another detective made the scene. Where were you at?
In the office.
The office?
Correct.
And you stated that a witness was coming down. Do you remember the name of that witness?
Esvalon Lewis, I believe.
And I see that you're looking at something. Can you please just tell me what you're looking at right now?
This is my report. It's called the prosecution guide.
And so in that guide, do you put in there names of witnesses or other type of investigative things that you've done?
That's correct.
And so you can refresh your memory with that. Well, please don't read directly from it,
Correct.
but you can refresh your memory, okay? And can you just refresh your memory on the name of the individual that came down?
Esvalon Lewis.
And
As far as
did you interview her that night or that day rather?
I did.
And was that done at the headquarters?
Correct.
And through that interview, were you able to gain some more knowledge of the actual murder and the murder scene?
Correct.
And at that point, were you developing a suspect in this case?
We were.
And after that interview, were you able to interview anybody else in this case?
Not that day.
And then through your investigation, were there other witnesses that were deemed important in this
Correct.
case? And was there anybody else interviewed that day? Maybe not by you, but by any law enforcement?
There were.
And who was that?
I know there was one of the maintenance guys, personnel, I think his name was Carl.
Carl? Okay.
Another resident who had approached an officer. That's far.
And so throughout that process, you gain information, develop a suspect, and proceed with the case. Is that correct?
That's correct.
In this particular case, were you able that day or soon thereafter able to talk to the defendant that's charged in the case?
Not that day.
So back on March 31st, 2022, was the defendant in this case, was he apprehended that day?
No.
Do you know when he was apprehended and brought in for questioning?
From my recollection, he was apprehended sometime in June.
And when?
June of 2022,
June of 2022. And where was he apprehended at?
Wichita, Kansas.
Wichita, Kansas. And how was he apprehended? Why was he apprehended in Wichita, Kansas?
He was apprehended, I believe, by the U.S. Marshals, and because he had an arrest for murder.
Was there an arrest warrant issued for him?
Correct.
Okay. And was it for this case?
It was.
I'm so sorry. Could the parties approach?
Did you find this interview or what he was saying to correlate with video evidence in this case?
He did.
And did he ever state that he was at the scene?
He did.
Did he state that whether he knew or who did the shooting?
He did mention.
And did he ever tell you who he said did the shooting?
No.
And did he ever acknowledge to you what type of clothing he was wearing that day?
He did.
And this was all be contained in the video statement?
That's correct.
And Your Honor,
Yes.
may we approach or?
Yes. All right, ladies and gentlemen, we're going to take a 10-minute break. Is there something I need to take outside your presence? Remember my previous instructions. Does everyone understand?
Yes.
All right, everyone, please rise for the jurors.
This is the beauty of watching stuff on playback. You skip all the rubbish stuff. Like,
Everybody's getting their steps in today. All right, everyone, please be seated. And State, you may continue.
Thank you, Judge. Detective Espinoza, after your investigation with the witnesses, evidence in this case, what was your determination and who to charge for this murder?
The facts led to charge Vernon Dixon with murder.
Thank you. We'll pass the witness, Your Honor.
All right, defense.
One moment, Judge. Your Honor, we have no questions for this witness.
All right, is this witness excused or subject for recall?
Excused by the state, Your Honor.
Excuse by the defense, Your Honor.
All right, the rule has been invoked. What that means, you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes, ma'am.
All right, you may step down.
no worries, that's fine.
All right, State, call your next witness.
Your Honor, the state would be offering state exhibit number 39 into evidence at this time.
I believe this was previously ruled on, Judge, outside the jury's presence, and we have no objections as it's being offered.
All right, then State's exhibit number 39 is admitted without objection.
And Your Honor, it's the waiver of consent to stipulation of testimony and stipulations stating that the defendant in this case, Vernon Dixon, was charged and convicted of the felony offense of possession of cocaine under 28 grams on July 20th, 1992, and cause number 1991 CR 0678 in the 187th District Court.
All right, and defense, you stipulated to State's exhibit number 39, correct?
We have, Judge. We've had a chance to review and everyone signed and we agree to stipulate.
All right, then State's exhibit number 39 is admitted.
Maybe I just publish it for the jury, Your Honor.
Yes. All right, State, call your next witness.
At this time, Your Honor, the state would rest.
All right, defense.
Your Honor, may we take up a motion outside the presence of the jury?
Yes.
Thank you.
All right. But ladies, we're off the record. Ladies and gentlemen, I'm anticipating, and both the state and the defense have told me that they expect both sides to be finished today. So even though you're doing back and forth, things are actually happening. So I'm going to have you all go to the back, and I will call you back at 2:50. And remember my previous instructions. All right, everyone, please rise for the jurors.
Yes.
All right, everyone, please be seated. All right, and defense, you have motion?
Yes, Your Honor. At this time, it's my understanding the state has rested their case and the defense would respectfully move for an instruction of acquittal in this matter. To illustrate as to why we believe we are entitled to such, Judge, we point out that there is a shocking lack of physical evidence on this case.
Oh, you may remain seated.
Oh, if it's okay, the court, may I stay standing?
Sure.
Sorry, it's been sitting a lot today.
Okay.
Back's hurting me. Judge, there's been a lack of physical evidence on this case, and furthermore, I think a lot of confusion over testimony. And I believe the standard that we have to ask ourselves is, could any reasonable juror come to the conclusion that Mr. Dixon is guilty as to the offense of murder? And I believe that there has been insufficient evidence shown that a reasonable juror could jump to that conclusion, could reach that conclusion, Judge. Again, we've had testimony contravened per people saying that we were there. Defendant goes by the name of Juicy, said he didn't see any shooting. He's 15 feet away or so. People that hear gunshots but don't necessarily see a shooting going on. Again, a lot of assumptions, a lot of conclusions, but it's a serious lack of physical evidence, Judge. And we believe that all comes down to the fact that no reasonable juror could reach a verdict of guilty in this case. And respectfully, Your Honor, we would ask the court to instruct the jury to move for a verdict of acquittal in this matter.
Thank you. All right, State.
Your Honor, the state's position is we have proven every element of the crime, including count 1, count 2, and count 3 in this case, Your Honor. eyewitness testimony, including security video footage of at least 2 different angles of the actual shooting or the scene that day, including other evidence, the raw evidence at the scene, and also the medical examiner, lab scientist testimony brings into the fact that the elements have been met, and this should be going to the jury for guilt or not guilt deliberations.
All right. Defense, it's your motion. You have final argument.
No, Your Honor, we will rest on our previous argument as stated, Judge.
Judge, bottom line is real simple. You can look at the video and you can't tell who does the shooting. That's really the bottom line in terms of the facts that have to be determined by this jury.
All right, thank you. All right, defense's motion is denied. Defense, are you calling any witnesses?
Your Honor, may we confer with our client just for a few minutes?
Sure.
Actually, I'm gonna step out with Mr. Schaefer and talk with somebody, and we'll be right back.
All right, of course.
I was speaking to you when I was muted. Jonathan Mexie's got a question for you, but he might not be there. He
All right,
might
so
be
we'll
ill.
put this on the record. The court is calling 2023 CR 3852, State of Texas versus Kaylin Johnson. Can I have parties announced for the record? of the
Okay,
state?
this
Defense.
is a different trial.
And Ms. Johnson is, hi.
Yes.
Oh, you're here for 5 cases.
It's
Seems like.
Unless you want to talk about it.
And when you get a chance, could you bring me the file on?
No, none of this is to do with this trial. You better jump. Nope, nothing to do with this trial. You better not cry. Better not, I'm telling you what. Santa Claus is coming to town. Dee 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 dee. Dee 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 dee. Dee 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 dee.
Oh, they should. If they do not, they'll
Okay, that's done then. Let's go. Let me just have a look to see. Maxi, taxi, Jonathan. Where are we? Right. I think this is number. You better not cry. Telling you what. Santa Claus is coming to town. Santa Claus is coming to town. Santa Claus is coming to town. Okay. Okay, I'm just going to where closing arguments start. Right, I got it. I got it. Yeah, baby, I got it. Alright, we're down to 3 people watching, so it's Maxie, Jonathan, maybe Emma. I saw Mama kissing Santa under the mistletoe last night. I don't remember the full words of it, the tune of it. Dee 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 dee.
Yes, Your Honor.
Right, state closing.
I very briefly wanted to cover a few things that are found in the jury charge. You're going to hear from the defense, and then you're going to hear from Jason one last time before we're done. So, as the judge mentioned, there are 3 counts in this case: murder, unlawful possession, and tampering with physical evidence. Now, each of these are independent of one another. You have to consider, did the state prove the elements in each count independent of one another beyond a reasonable doubt? So let's start with count 1, murder, separated into 2 paragraphs. Now, what that means is that it's paragraph A and paragraph B. One juror could say that they found beyond a reasonable doubt paragraph A, and then the rest can all say paragraph B. It's just that it's unanimous that it's one or the other. So let's start with unanimous that it's one or the other. So let's start with paragraph A. It's on or about March 31st of 2022, Vernon Dixon in Bexar County, Texas, intentionally caused the death of Avante Boyce by shooting him with a firearm. Now, there have been many witnesses who have come forward and said that those events happened. They explained that through their testimony. And again, it's each individual part. It's the date, where, who, shooting, intentionally causing death by shooting a firearm, which is a deadly weapon. That's what everyone agreed on. So paragraph B, it's again, on or about March 31st of 2022, the defendant Vernon Dixon, with the intent to cause serious bodily injury to Avante Boyce, committed an act that was clearly dangerous to human life, shooting a firearm at Avante that caused his death. Now again, it's not that he intended to kill, it's that he intended to cause serious bodily injury. How do we know that? He shot him with a gun. You are intending to cause serious bodily injury when you do that. And it's clearly dangerous to human life because you can't say what that bullet's going to do to a body once it hits. So then moving on to count 2, it's unlawful possession of a firearm. So the defense in States 39 stipulated that the defendant was convicted in, it was 1992 CR 0678. So that's already been stipulated to, that he was convicted. Now it's looking at, did he possess a firearm? Many witnesses came and said he was the one who had the gun. Next, was it in a public place? Well, he didn't live at that apartment complex. He had access to it. Several people had access to that apartment complex and that patio area. So it was a public place. Then the next one, it's count 3. It's tampering with physical evidence. Now, a witness came and said, it was Donald Neely. He said that after the shooting, Vernon handed him the firearm. And that's why the firearm wasn't found. He handed it off with the intent so that it couldn't be found. When you hand it off to someone, you're not saying get rid of it. Now, again, each of these are independent of one another. It's, did the state prove each count beyond a reasonable doubt? Now, you aren't going to get any of the police reports that have been referenced to by several of the witnesses. That's not going back there. You can't let bias or sympathy play a role in your determination today. The question you have to answer is, for each count, did the state prove these elements beyond a reasonable doubt? We have. We brought many witnesses to say what happened that day and how Avante lost his life. We have proven on each count that he is guilty. Thank you. And the state reserves all time. Thank you.
All right, defense.
Yes, Your Honor.
May it please the court, counsel for the prosecution. Good morning, how are y'all today? The first thing I want to say is the charge of the court. I'll remind you that with you to the jury room, so don't worry about trying to remember what we said, what like that. It's all in here. The judge has the law. The lawyers have their duties. The state wants to convict Vernon Dixon. Okay, they want you to find him guilty. Remember that what we talk about here, we lawyers, is not evidence. Okay, evidence is that which the court admitted from the witness stand. We all have our views, we all have our opinions, but what we say is not the evidence in this case. The real bottom line here is, what does the evidence say? Okay, what does the evidence say? The state produced a video in this case, and you have to look at the video. And the state has alleged that the murder occurred at 3 o'clock with 49 minutes and 41 seconds. Look at the video. Because some of the witnesses said, oh, he did it. And some of the witnesses say, we don't know who did it. What's that? That's a reasonable doubt. That means that the state has not proven this case beyond a reasonable doubt, as they are required to by law. The video. Some of you think maybe he did it. And some of you are wondering, did he do it? That right self, that in and of itself creates a reasonable doubt. If you don't know who did this, then you must find him not guilty. I've looked at the video. Y'all have looked at the video. Look at the video again, and in your own mind, decide, do I see Vernon Dixon shooting the gun and causing the unfortunate death of Avante Boyce? I can't tell you that. You have to decide the facts in this case. The bottom line is you have to decide the facts, and you have to decide maybe he did it. Maybe he didn't. What we don't know is that there's at least half a dozen people there present. We don't know who shot Avante Boyce. And if we don't know it, you don't either. That, ladies and gentlemen, is the reasonable doubt that you have to go back to the jury room and make your own mind up. I'll remind you of some of the instructions in the charge. Each of you has to make up your own mind. I don't want you to say, well, I'm going to go with the rest of the jurors because I'm in the minority and they're a majority. Each of you has to make up your own mind. We want to go ahead and thank you for your service in this case. We want to thank you for your verdict. We look forward to hearing back from you.
May I please the court, state? Good morning, ladies and gentlemen. Thank you all for being here. It's been a long, I think this whole thing started about a week ago, and we understand that this was not an easy sacrifice for anyone, but without you, this whole process can't happen.
Hi, Christine.
State of Texas.
What do you need?
Mr. Schaefer told you is correct. Burden of proof in a case. The burden of proof is always on the state to prove, and they must prove each and every element of every offense. If you have reasonable doubt as to anything, any of the elements, whether this happened in Bexar County, a date, any of the elements in there, then you must return a verdict of not guilty, and that goes for all three counts.
To be honest, Christine, yeah. Look, we always post about you. I think everyone here is a member of your channel. We always post about you, Christine, whenever you come in. Because you're a member, I always post it. I think Jonathan, Mecky, Emma, they're all members of your channel. I can guarantee you there's probably 20 or 30 members you got from this channel, Christine. But yeah, they're all members. But we can still promote you next week and everything. We'll get you more people. Don't worry, Christine.
Of murder, felon possession of a firearm, and tampering with evidence. Remember we talked about modality levels. We have reasonable suspicion on the very far end. That's enough for a traffic stop. Beyond that, we have probable cause, which is burden to arrest. And that's less than 50%. Beyond that, we have preponderance of the evidence, which is just a little bit more than 50%. Beyond that, clear and convincing evidence, which is excuse me, you see this in a CPS case, Child Protective Services. It's enough to remove a child from a parent's home and place them within a family. And then beyond that, we don't know exactly where this level is. We leave it to each and every juror to decide for themselves. Is beyond a reasonable doubt. It is the highest burden that we have, and it's the highest for a reason. Because what you're deciding here today is life or liberty for somebody. This is the only kind of offense, criminal offenses, that can result in somebody being thrown in prison, thrown in jail. And for that reason, our law says that you must be convinced beyond a reasonable doubt. What is presumption of innocence? I think we told you at the beginning. It's the only presumption that carries through a verdict, through a jury trial, all the way until the verdict is rendered. As he sits there today, Vernon Dixon is presumed innocent. And I'm going to suggest to you that the state failed in their burden to prove beyond a reasonable doubt that he is guilty of any of the offenses today. And why is it important? It's because it's the only presumption we have in a criminal case. It's what protects us all. Again, we talked about three possibilities. Guilty. That's an analogy. You have a horse race and it's a runaway. You have guilty, not guilty, and then you have this last one, not sure. You look here, if you remember, it's like a horse race in the moment, kind of hard to tell. You know, somebody won by a nose. If you are unsure, if you're left there with a doubt, that is your doubt. That is your reasonable doubt. And not sure is not guilty. I'm going to talk about what you have. You have a blurry video, and Mr. Schaefer mentioned it. Go back and watch the video. It's admitted in evidence. You can watch both of them. Take a look at it frame by frame if you want and see. You do not see the shooting on that video. You cannot tell who killed Avante Boyce that day. And uncertainty is reasonable doubt. I think I told you in opening that this is a case of missing pieces. The state is going to present evidence, but they're also going to have a lack of evidence. In this case, we have no fingerprints, no weapon, no GSR. If you remember GSR, we had, I think, 3 witnesses talk about it. Gunshot residue. You remember what Dr. Kanan said? Said that at a close quarter shot, something that happened so close range, you should see GSR on the burn wound. Even at a close range, it should be there. And you'll have the photos. It was not there. So does this match up with the state's theory that Vernon Dixon in close quarter shot and killed Devontae Boyce? I'm going to tell you it does not. Again, you had multiple people under that pavilion, multiple people that could have been the shooter. Talk about witnesses. You have Versa Austin, aka Juicy. They stayed kind of on the stand for a long time. At one point, they were arguing with him. He's about 15, 20 feet away from the car. He says very clearly, I did not see who shot him. And he's there, the perfect vantage point. You have Mr. Carl Cunningham. He said he saw something, but he's across the parking lot. You remember the photo they presented. That's also an evidence to you guys. He sees something going on. He hears a shot, but does he have a clear view of what actually happened? And my suggestion to you is no, he does not. Donald Neely goes by Raymond. He said Vernon handed off the weapon to him, yet he's remained silent about this for over a year. He says something along the effects of, I didn't think it was important. No one ever asked me. Well, does that make a whole lot of sense? You had something as important evidence. He admitted, yeah, I knew there was a shooting. Yeah, I knew something went on. Oh, by the way, this happened, but I didn't bother telling anyone about this until just a week ago. Why does that make any sense? And the answer is it doesn't. As for motives, we don't know. The state's not required to prove motive, nor is the defense. And lastly, we talked about Dr. Rajesh. Come on. So 2 wounds, 1 fatal. We're not questioning the cause of death here. This was a gunshot wound that killed Devontae Boyce. However, what was missing? No powder burns on the skin, which again, even through clothing at a close range with a firearm, 2 shots you should have seen, and we did not see it. This refutes the state's theory that this was a close range shot. And does this match up with the video? Someone as close as Vernon could not have made that shot. However, there's other people in the pavilion in that instant that very well could have been the shooter. Think about just the overall mood that day. There's high flying emotions and anger, and that makes for questionable testimony. We're going to come back to that. You heard that there's a fight. The girls are all fighting. And who's trying to break up the fight? You have Vernon, you have Devontae, and they're breaking this whole match up. Everyone's in the car. Things seem to be cooling off. And then for seemingly no reason, they want you to believe that Vernon gets out and shoots and kills Devontae in cold blood. Ladies and gentlemen, that doesn't make sense, right? We're going to tell you, don't leave your common sense at the door here. Nothing about this murder, about the offense here, the way the state has presented it, matches up to the evidence or makes sense it just doesn't pass the smell test. And remember, uncertainty leads to reasonable doubt, and reasonable doubt must lead to an acquittal. I think I told you at the beginning, this is a case of what's missing, and what's missing in this is absolutely crucial, right? You have bits and pieces of a puzzle, but you don't have the full puzzle. And you cannot convict, you cannot follow your oath and convict Vernon Dixon based on only partial picture, not in this case. We're going to ask you to return the only verdict which makes sense, and that is not guilty. I just want to talk to you a little bit more. Like I said, you've heard from a total of 15 or 16 witnesses in this case, and yet you're left, in my opinion, we're left with more questions than we have answers. We have a lot of questions left on this case. And again, we told you certain facts are not in dispute. Devontae Boyce is dead, and that is a tragedy. No one ever deserves to lose their life. You heard from E.B. Lewis, and it was the first or third witness that was called after 2 officers. She testified there's a fight, only 2 people trying to break it up. And again, does this make any sense at all? That somebody just randomly gets out and shoots and kills a person that just moments before they were working with? Or does it make sense that possibly there's a shooting, someone else is the shooter, and you just kind of jump to a conclusion? You make an assumption, yeah, this is the person that shot him. Think about Evie's vantage point. Back seat, Vernon's up by the front of the car. I'm going to suggest to you that she heard a shot, your brain puts 2 and 2 together, and it just doesn't match up. We talked about Versa Austin. He's standing there 15, 20 feet away. They had him on stand a long time. At the end, he had to say the same thing. Vernon did not shoot. He did not see Vernon shoot. And that's important. He's an eyewitness. He's right there. And he has a vantage point to see. And he's telling you that he was unable to identify him. Again, when you have inconsistent testimony, you have questionable testimony, it leads to doubt. And that's what you must infer and reach reasonable doubt in this case. And that's what we have. And that's what I told you at the beginning. That's what I'll tell you now. The state has failed to meet their burden. You may think, yeah, you can be 50%, even 60, possibly 70% sure we think this happened, but reasonable doubt is all that matters. And I'm going to tell you, I don't think the state has reached their burden. They have not proven this case beyond a reasonable doubt. Emily Dixon, she was on the stand. Again, emotions were high, kind of combative, but her answer was plain and simple. She did not see the shooting herself. And then we come back, we talked about Dr. Rajesh Kannan. He testified homicide by shooting, however, no GSR. And again, we cannot stress to you how important that is. close range shot. Based on the video, they're saying that if they're in close proximity, mere feet away, possibly just a foot or less, you should have seen DSR transferred, and yet you don't see it. And again, why is that important? It's because it does not match up with the state's theory of the case. It leaves a reasonable doubt. And ladies and gentlemen, it leads to the only verdict that we think you can legally and justly return, and that is a verdict of not guilty. Once again, thank you very much for your time, your patience, and your consideration throughout this whole process. You've been great jurors, and we appreciate your sacrifice for being here. No, Mr. Gadairhan's going to speak with y'all. Again, thank you. We'll thank you for your verdicts and respect your verdict. Have a good day.
Yeah, Your Honor.
Yes.
Defense counsel.
Counsel.
Ladies and gentlemen, I'll be the last one to talk to y'all today. And then you will go back to the back and deliberate on this case. And I'm gonna briefly go through some PowerPoint because apparently that's what all these lawyers do now. So I felt that I need to do this. And let me make sure I got it. Okay. Elements of the crime. Daniel's already gone over this and y'all seen this many times, but I just want to reiterate these elements. The date is not in question. Bear County, Texas. You heard officer testify to that. Defendant has been named in this case. Intentionally knowingly, that's up to you. But the fact is, I think beyond a reasonable doubt, we met that burden many times over in this case. Causes of death. We have that victim, Levante Boyce. We have that already. The fact is that it was done by a shooting, and as defense counsel said, it was done with a firearm. The shooting is a deadly weapon. That's paragraph A. Paragraph B, if you feel that's appropriate, that's fine. Act clearly dangerous to human life. Shooting at somebody that's sitting in a car, that's act clearly dangerous to human life. I'm going to go on to count 2, unlawful possession of a firearm. Again, date, Bear County, Texas. The defendant, that's not in question. Possession of the firearm. Again, that's part of the elements that we have to prove for this count 2. Without a question, he's been possessed of a firearm. Many witnesses already testified to that. Many witnesses, 4 to be exact. After a felony conviction, which defense has already stipulated that he has a felony conviction that's passed, you'll see that felony conviction, the judgment, that it's been over 5 years since he's been off of parole or community supervision or imprisonment. So the fact is, it's already after that 5th anniversary release from confinement or probation. So that's not a question. It's a public place. This is the parking lot. He is not to be possessing a firearm for the rest of his life anywhere other than his own home. In this case, it was in a public place, which is a parking lot of that common area. Tampering with evidence, again, the first part's already established, but knowing an offense had occurred, he knew an offense had occurred. At least at that point, he knew an aggravated assault with a deadly weapon had occurred because he had shot at another individual with that deadly weapon. That is an aggravated assault with a deadly weapon. That's a felony. Intentionally and knowingly concealed this thing, the firearm, which he did. I mean, you had testimony that he had from 2 different individuals that he handed the gun off to somebody else. You've seen it in the movies. Why do you hand a gun off? You get rid of it. Get rid of the evidence. What are you going to do if something happens? Somebody gets shot. You get rid of the evidence. That's what he was doing. He was tampering with this evidence. So again, count 3 is not even in question in this case. So again, I think defense counsel said it, and I said it during board hire. Don't check your common sense in at the doorsteps of this courthouse. It's common sense. Use your reasonableness to get that beyond a reasonable doubt. In this case, the state's confident that this is beyond a reasonable doubt. There's not a question of who killed Levante Boyce. It's not a question. Your common sense tells you that. Your common sense tells you this man over here sitting is the one that pulled that trigger that day. And how do we know that? Let's talk about the evidence in this case. Testimony of witnesses. Not one lay witness, meaning a person that's not law enforcement or the ME's office or CSI. Not 1, not 2, not 3, but 7 different witnesses on this case came in. 1, 2, 3, 4 are related to the defendant. His own family came in. Call her Evie Lewis. His stepdaughter, person that he considered his stepdaughter, came in, testified. Who is Levante Boyce to you? She said, I consider that my husband. We have children together. I was pregnant at that time. I had my second one after he died. But what do you consider the defendant in this case? That's my dad. Known him since I was 7 or 8. And she points the finger at this individual. Within feet of her child in the back seat with her, this man here takes a gun and shoots Levante Boyce while he's sitting in the front of that vehicle trying to get out from this man. And he knows he did it because the fact is he was there in that white jumpsuit. He knows that. The fact is, you know that. His stepdaughter knew. And that little boy in the back seat with her, Levante Boyce's son, was within feet of his father being killed by that man over there. She testified to that. Now let's go to I'm unique. Biological daughter of the defendant came in and testified. Raise your hand, Dad. That's him right there. Yeah, she was angry. She didn't want to be here. We had to drag her in, but we brought her to you. And yeah, she was not the most hospitable. She was a little hostile at times, right? But one thing that came out was the truth. Saw my dad with a gun coming around. He had that gun. He was mad at me, pushing me when we were arguing with his stepdaughter. That, by all accounts, she doesn't like. That's fine. But she came in and testified, Dad had a gun. You'll see on that video, and you'll see that still photos of that video, that she's on this side of the car. So yeah, maybe she did not hear what happened, or I'm sorry, see what happened, but she dang well heard it. And as soon as that happened, who came around that car? Vernon Dixon, with a gun in his hand. Go on to Donald Neely, her husband. What did you hear him say? When Vernon Dixon came around that car, he said, look what you made me do. I want you to remember that phrase. Look what you made me do. He said he handed the gun off to him. He was scared. He's the son-in-law of this man over here. The son-in-law, another family member. Go to Pearl Barnes. She was there at that scene. You look at that video. Pearl saw everything that happened. But who is going to come in and testify against their own child? That's his mom. I understand that. You understand that. She was there. She was watching. She saw him. She took him from the scene. She said, why'd you do this? Remember that. Carl says that. Heard a woman's voice coming from that car as it sped out of the parking lot. Why'd you do this? Plain and simple. That's his mom. Go on to Versa Austin, aka Mr. Juicy. It's homeboy, right? Who's going to testify against their homeboy? Juicy was certainly not going to testify against his homeboy. We all know that. He looked down the whole time, didn't want to look, make eye contact, was not cooperative. The judge informed him to answer the question several times. Last question I asked him, are you scared? Yeah, he's scared. He has to go back and live over there. He has to walk around those streets. Yeah, he's scared. Go on to Carl Cunningham. Independent witness. This maintenance guy. Took that picture of this individual over there in that white tracksuit. Very identifiable, might I add, the white tracksuit.
Noon.
He testified that was
None.
knew him as Vernon King, and then
What do you want? Noon or none? How do you say the word none? Hi, Dunya.
that last phrase, he said Vernon King Dixon. Saw him with a gun, saw him shooting that car, saw him come around and hand that gun off, get in that car and take off with his mama, and heard her say, why did you do this? Belinda voice brings in something very interesting, a voicemail, what I call the butt dial in this case. Let's talk about that, the additional evidence, but I'm going to skip to the voicemail. The voicemail. What was said on that voicemail? You can't hear a lot. It's a little mumble jumbled. I mean, if anything, you need to listen to that again. But one thing you will listen and hear on that, something that sort of goes with what Donald Neely said. On that voicemail, you will hear, they made me do it. What did Donald Neely say that the defendant said when he came around that car? Look what you made me do. Listen to that voicemail. It says that. We already heard from Evie that that person is Vernon Dixon saying that. That corroborates between Donald Neely, what he testified to, and that voicemail. That's a match. Another match in this particular case is Carl saying that that gun was handed off to who? Donald Neely. Why would he make that up? That leaves credit to Donald Neely of what he said. You look at these pieces of evidence that come in, those puzzle pieces, and they're falling into place. Clear cut. It's beyond a reasonable doubt. It shows that those puzzle pieces make a very clear picture. The security video in this case, without question, hey, I would love to have a video of every murder that I ever tried, or for that matter, any murder that ever happened. That would be great. But this is not a perfect world. This is not a perfect scene. The fact is, we don't have the actual shooting, the smoking gun in his hand. But you got testimony that's credible, that you match it up with another puzzle piece, which is the videos on two different angles. And it's very clear. It's beyond a reasonable doubt.
5 minutes.
Thank you, Your Honor. The white tracksuit, which I really, in this case, seals his fate. So identifiable from across the parking lot. Yes, there might be a tree, and Carl kind of gives his photo, but what you can see clearly through that tree and those leaves is a white tracksuit standing there with his arm up. It's clear as day. Talking about GSR and defendant's vehicle, there's GSR on the headliner and GSR on that seat where Avante Boyce was killed. No GSR was ever found on his hands, meaning that he most likely did not possess a gun or anything. In this case, there's been no evidence that Avante Boyce did anything except for try to stop a physical altercation between females at the scene and got shot by this man senselessly. Bullets that were found in Avante Boyce came from the same revolver handgun. You heard the doctor in this case testify to that. You heard the lab technician scientist come in and testify to that. Both shots came from the same gun. The defendant fled from the scene with his mom. It's not a question. And then he fled to Kansas. You can use that as guilt against this individual. If you flee a scene after you shot someone, you're guilty of murder. In this case, he's guilty of murder. You're going to see in that video, if you need to watch it again, but you've seen it several times, but there's several different clips. I put still video photos in so you can look at the times on those still videos or photos and be able to match up for the video. But you've seen the video several times. Mom arriving. Defendant in that white tracksuit, identified. That white tracksuit again. You see it from across the whole parking lot, that white tracksuit. Again, photo by Carl. White tracksuit. You see the defendant at moments after the shooting. The defendant's on the other side of that car. I put two yellow circles on this in particular. If you look at this, the circle to your left, all the way to the left. You know who that is? Mr. Juicy. Because what did Mr. Juicy say? One thing that he said over and over and over: if I hear gunshots, I'm running. I'm out. He's all the way across the parking lot. Gunshots have happened. Victim is laying outside that open car door, and the defendant is coming around with that gun in his hand, and everybody else is standing there. And I don't know if you can see this, but I'm looking up there and I see Miss Pearl right there in the middle, leaning up against that picnic table. Because if you watch the video, Pearl walks to that car. She identified herself. She saw the whole incident. Right after, defendant handing off the gun, circled in yellow there, to Donald Neely. Pearl and the defendant leaving that white tracksuit, get into that car. And if you did catch this video right here, the still shot shows that white tracksuit, and again, there's that white tracksuit following him throughout this case. Him pointing to his mom to take a right. The puzzle pieces equal a clear picture, and it points in one direction, only one. It's that direction right there. Vernon Dixon shot Avante Boyce for no damn good reason. It's senseless. It was stupid. And yeah, it doesn't make sense. But use your common sense and your reasonableness in this case. The defendant is guilty of murder on count 1, unlawful possession of a firearm on count 2, and tampering with evidence on count 3. Plain and simple. Vernon Dixon is guilty of murder, and hold him accountable, please. Thank you.
All right, ladies and gentlemen, you have heard all the evidence that you're going to hear in this part of the trial. So I'm going to send you back to the jury room. But before I send you back, if I could have Miss English and Miss Priest, please remain. All right, everyone, please.
Okay, right, let's get to the verdict. Let's get to the verdict. The verdict. Ba, 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 ba. Oops, where? Dun, 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 dun. I think that's the. What's this for? Dun, 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 dun. Dun, 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 dun. Okay, hang on. I don't know what this is for. All right, present. Share screen. Dun, dun.
All right, we're going to go on the record. Court is going to call 2022 CR 9807, State of Texas versus Vernon Dixon. Can I have parties announced for the record for the state?
Jason Garahan and Daniel Escobar for the state, Your Honor.
Defense?
Adam LaHood and George Schaefer for the defendant, Vernon Dixon.
All right. And are you Mr. Dixon?
Yes, Your Honor, if we,
Just 1 second. That's okay. All right. So I'm sorry, if you could re-announce defense.
of course, Judge, it may please the court. Your Honor, in discussing this with my client, Mr. Vernon Dixon has decided to voluntarily absent himself from this portion of the trial. Obviously, a verdict has been rendered as to guilt innocence. He has chosen not to be here for the punishment phase. We do have all appropriate stipulations signed and before the court.
Oops, I'm in the wrong video. I'm in the wrong video. Hang on. I'm in the wrong. Where is the verdict? Well, I thought it was here somewhere. Because it says it, verdict. I think this is it. All right. Right, here we go. Right, I've got the verdict here. Sorry, guys, I didn't realise that I was in the wrong one. Dee, 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 dee.
All right, and is that verdict unanimous as to all counts?
Yes.
All right, if you'll hand the verdict form to the deputy, please.
Da, 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 da.
All right, it appears that the verdict form is in order. If the defendant will please rise.
Kim, will we go into that one? Because that's the sentencing. So he's obviously guilty then.
All right, count one reads, we the jury find the defendant Vernon Dixon guilty of the offense of murder as charged in count one of the indictment. Count two reads, we the jury find the defendant Vernon Dixon guilty of the offense of unlawful possession of a firearm as charged in count two of the indictment. Count three reads, we the jury find the defendant Vernon Dixon guilty of the offense of tampering with physical evidence as charged in count three of the indictment. You may be seated. Does anyone wish to have the jury polled?
Defense respectfully request to have the jury poll.
All right, thank you. All right, ladies and gentlemen, what I'm going to do, and I know we have alternates in the
Okay, so he's found guilty. Then we go back to the other one. Which one is it now? 25, wasn't it? Oh, let me find it. think we're the wrong one again. Hang on. Well, there's two of these, so hang on. Let's just play this one first then. Presents.
You, Mr. Dixon,
Yes, Your Honor, if we,
just 1 second. That's okay. All right. So I'm sorry, if you could re-announce defense.
of course, Judge, and may it please the court, Your Honor, in discussing this with my client, Mr. Vernon Dixon has decided to voluntarily absent himself from this portion of the trial. Obviously, a verdict has been rendered as to guilt innocence. He has chosen not to be here for the punishment phase. We do have all appropriate stipulations signed and before the court, or they will be here shortly. Again, this was his decision. We respect that decision. He's not required to be here for that. And so we will be proceeding to punishment without Mr. Dixon this afternoon.
All right. And defense, did you have ample opportunity to discuss this with your client?
I have, Your Honor, and he has made the decision knowingly and voluntarily.
All right. Thank you. The next issue that we put on the record was with regards to competency. And I know that was previously placed on the record.
Yes, Your Honor. Just to recap briefly, a competency evaluation was conducted this morning by Dr. Michael Jumas, PhD. We had a hearing on this previously, but just to recap, it is the opinion of Dr. Jumas that Mr. Dixon is presently competent to proceed to trial. The defense is satisfied that he is competent, and we are not requesting any further evaluation on that matter based upon the testimony and advice of Dr. Michael Jumas.
All right. Thank you.
Thank you, Your Honor.
Is there anything for the state to put on the record before the jury is brought in?
No, Your Honor.
All right, then let's bring the jury in, please.
I don't really know what's going on now. I'll be back though.
Yes, sir. I think it's on page 4. Yeah, page 4.
In just one moment. Before the jury is brought in, state and defense, have you had a chance to review the jury charge for punishment?
Yes, Your Honor.
Yes, Your Honor, we have.
Any objections?
Not from the state, Your Honor.
We do not have any objections, and just for clarification of the record, this is the one that on page 4, it does have language about the defendant voluntarily absenting himself from the hearing. And
Yes.
we have no objection as presented.
All right, thank you. All right, let's bring the jurors in. All right, everyone, please be seated. All right, ladies and gentlemen, this is the second phase of the trial. State, do you have any opening statements?
No, Your Honor. We'll wait to wait. Opening statement.
Defense?
The defense is fine waiving the statement, opening statement, Judge.
All right, state, do you have any evidence to present?
Yes, Your Honor. At this time, the state's going to offer State's Exhibit number 41. It's the waiver and stipulations concerning clause number 1993 CR 6163.
All right, if you could slow down just a little bit.
Sure, Judge. 1993 CR 6163 and 2006 CR 72148. That's the defendant's waiver and stipulations concerning these.
All right, any objections to state's exhibit number 41 that's been stipulated to?
No objections, Your Honor.
All right, then state's exhibit number 41 is admitted into evidence without objection.
And Your Honor, permission to publish.
Granted.
And very briefly, this is from the second page of the waiver and stipulations. It reads, I, Vernon King Dixon, do hereby judicially confess and admit that on the 13th of December, AD 1993, in cause number 1993 CR 6163, in Bexar County, Texas, the defendant Vernon Dixon was convicted of the felony of possession of cocaine under 28 grams. And after the conviction in cause number 1993 CR 6163, was final. The defendant, Vernon Dixon, committed the felony of possession of controlled substance, PD1, 4 grams to 200 grams, and was convicted on the 29th day of October, AB 2007, in cause number 2006 CR 7214A in Bexar County, Texas. It was signed by the defendant.
All right. And with regards to those stipulations, defense, I realize it's a stipulation, but for the record to be clear, what was it your intention and your client's intention that those stipulations were in fact a plea of true to the enhancement allegations?
It was, Your Honor. The defense will stipulate as to the enhancement allegations presented, and it is our intention to plead true to those enhancement paragraphs.
All right. Thank you. State, any other witness, any other evidence or witnesses?
No, Your Honor, the state will rest.
All right, defense.
Your Honor, the defense will rest. We just have argument.
All right. Thank you. Do both sides close?
Yes, Your Honor.
The defense will close.
All right, ladies and gentlemen, I'm going to read to you what's the charge of court for punishment. Again, you do not have to memorize this. You'll be given it when you get ready to deliberate. Charge of the court on punishment. Members of the jury, the defendant, Vernon Dixon, has been found guilty of the offense of murder as charged in count 1 of the indictment, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment, and guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. The habitual offender enhancement allegation in the indictment alleges that before the commission of the offense alleged above, hereinafter styled the primary offense, on the 13th day of December, 1993, and cause number 1993 CR 6163 in Bexar County, Texas, the defendant was convicted of the felony of possession of cocaine under 28 grams. Before the commission of the primary offense and after the conviction and cause number 1993 CR 6163 was final, the defendant committed the felony of possession of a controlled substance, penalty group 1, 4 grams to 200 grams, and was convicted on the 29th day of October 2007 and cause number 2007 CR 7214A in Bexar County, Texas. To these above stated enhancement paragraphs and the habitual offender enhancement allegation in the indictment, the defendant has pleaded true. You will find the defendant has previously been finally convicted of at least 2 felony offenses as alleged in the habitual offender enhancement allegation in the indictment, and that the second previous felony conviction is for an offense that occurred subsequent to the first previous conviction having become final. You will so state in each of your verdicts that you will find true the habitual offender enhancement allegation in the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years in each count. In this case, evidence has been admitted to the fact that the defendant may have committed an offense or offenses other than that for which you have convicted him. The court instructs you that you may consider this evidence, if any, in determining what sentence is appropriate in the case at hand, but you may only consider the evidence if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses. Our law provides the defendant may voluntarily absent himself from trial if he elects to do so. This, however, is a right accorded a defendant. And in the event he elects to absent himself, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected to be absent during this punishment phase of the trial. You are instructed that you cannot and must not refer or allude to the fact that throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to be fixed the same by lot, chance, any system of averages, or any other method than by full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. With regards to count 1, you are instructed as follows. The defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. With regard to counts 2 and count 3, you are instructed as follows. The defendant may earn early parole eligibility through the award of good time conduct. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. The defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed, or 15 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts, if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed with closing?
Yes, Your Honor, we'll reserve all closing time.
All right, defense.
Thank you. Good afternoon, ladies and gentlemen. This will be the last time that I get to speak with y'all. And again, I want to start how we started this whole trial, and that is to thank y'all. Thank y'all for your time, your service, and ultimately your verdict. We respect your verdicts, and ultimately it was your decision. Without you, this process just does not work. I want to just talk to you briefly. I'm not going to take much of your time. You heard the evidence, and I think you understand the punishment range that we're facing here. Minimum of 25 years, and that's where it begins. This is because there's 2 prior felony convictions, which we have stipulated to. However, take a look at the prior convictions. They're both drug offenses. This is the first violent offense that Mr. Dixon has been convicted
You just
of.
answered it for you, Dunia.
And we respect your verdict in that matter. I just want to give you a few things to think about and consider before you go back and deliberate. And the state will talk to you after me. Vernon is 57 years old. 57. That means if we assess even the minimum punishment, 25 years, which is on the murder charge, in the charge it tells you that it will have to be at least half time served, just 12.5 years. So you take somebody that's 57, they're looking at minimum 12.5 years. That puts them into their 7 years old. And parole is anything but a guarantee. Anything but a guarantee. This is nothing, it is far from guaranteed that parole board may ever grant parole in anything. We ask you to consider the fact that we have a person that's 57 years old, not in particularly great health, and to consider what would be an appropriate sentence. I would suggest to you, and in fact, I would plead with you to please consider a punishment on the lower end of the range. Again, this isn't a 5 to life offense like it would normally be if there weren't for 2 prior convictions. This starts at 25 years, a minimum. If you feel the minimum is appropriate, we would certainly be appreciative. But I would suggest to you that even with a minimum sentence on this case, there's a very good chance that Mr. Dixon, quite frankly, will be dead in prison before he's ever given a chance.
He had 2 felon convictions before this murder. Yeah, he's just said he had 2 felon convictions before this. So it would have been a 5 to whatever, 5 to life, but now it has to be a minimum 25 years.
Answer eligibility for parole. Ladies and gentlemen, thank you again for your time, your patience, consideration over this last week or so. I sincerely mean it. I know the state's going to talk to you, and ultimately we'll thank you again for your verdict and decision in this punishment phase. Thank you all very much.
State.
Yes, Your Honor. Ladies and gentlemen, I'll be the last person to speak with you. And I do respect your verdict, and I do appreciate your deliberations and your time that you've spent here for the last, I guess, roughly week, a little bit longer than a week. This is the last hours, or at least the last day, hopefully, that you will have to sit here and deliberate on somebody else's future and their liberty. But I just want to go over a few things with you. So you came back with guilty on each count. And for Vernon Dixon shooting Avante Boys. Again, the range of punishment is a minimum of 25 years to 99 years or life on each count. And I'm going to tell you, these sentences are all going to run concurrent. Nobody's spoken to you about that. They're what we call stacked is not going to happen in this case. That means that they will run at the same time. So if you give life on count 1, and they give 50 years on count 2, and then 40 years on count 3, all those run concurrent. That means they each start ticking away the years as soon as he gets sentenced and sent away. So really, the one on the left and the one on the right are the same thing. Count one, count two, count three, life. I'm going to tell you this, we're asking for life because of the egregiousness of this type of crime. Because remember, in the end, he committed this on his, what he considered his own family, his step's son-in-law, in front of children. You remember the scene that the defendant fled from the scene. He fled off to Kansas. The defendant was running away from his responsibilities. His responsibilities, if you look at this scene with the children all over the crime scene, you see the yellow circle there. Those kids are coming home from school. If you look at the next moments before the shooting, there was children all over that scene. One in the car, which is Avante Jr. Another, Juju, which is on the right, sitting underneath that pavilion. Then the individual getting out of the car, coming back from school. During the shooting, Avante Jr. is in that car. Evie's in that car, pregnant with his brother, and Avante's unborn son. After the shooting, Evie's standing there with Avante Jr. After the shooting, she's walking out with her child in her hands, Avante's son. The witnesses, we want to keep our community safe. Think of Juicy, how scared he was. Yeah, he wasn't being cooperative, and maybe he's a homeboy of the defendant, but he wasn't talking for a reason, because that's a future danger, because he's going to be at fault, even though he didn't say everything that he should have said. Carl, independent witness, future danger, future harm. Evie, he shot her husband. Unique, which is his biological daughter. Donald, which is a son-in-law, another son-in-law. Safety for the witnesses. The puzzle piece will show that this defendant is a future danger. Future danger to the children, future danger to the witnesses, to his own family, and to our community, the public in general. Let's seek justice for Avante Boyce's children. They won't be growing up with their father. Let's seek justice for a senseless murder, one of the most senseless murders that you probably will ever see, because somebody got upset, stepped out of a car when he had a choice to leave that scene, but instead, he could have shot that gun up in the air. He could have shot the car. He could have shot the dumpster. He could have shot anything, but he chose to aim it at another human being, which he considered family, and kill him. We're asking for a verdict of life on each count for the justice of Avante Boyce in this case. I do appreciate your time. I will tell you this, is that, like the judge said, and what Adam LaHood said, defense counsel, that parole is a possibility in this case. He will be paroled at some point, possibly. But if you assess life, the community, this family, these witnesses, those children won't have to fear Vernon Dixon anymore. So I ask from you as a jury, life imprisonment. Thank you.
All right, ladies and gentlemen, I will send you back. Again, the two alternates, you will be placed in a separate room. So if you need to remove your personal items from the room while you wait in the separate room, Deputy Mejia will.
Right, let's go straight to the verdict again then. Jesus, a lot of verdicts here, isn't it? Right, I think I got it here, ready. This is the verdict. This is the next day, verdict, I believe. Verdict. Verdict.
All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you have reached a unanimous verdict in this phase of the trial. Is that correct?
Yes.
All right, if you'll hand the verdict form to Deputy Mejia, please. Thank you. All right, the verdict form appears to be in proper order. To count one, it states that the jury is finding the habitual offender enhancement allegation to be true. They're assessing punishment at life. To count 2, it states that the jury is finding the habitual offender enhancement allegation true. They're assessing punishment at 60 years in the prison. To count 3, the jury is finding the habitual offender enhancement allegation true, and they're assessing the punishment to be at 60 years in the prison. Is there any request from either side to have the jury polled with regards to punishment, state, defense?
No, Your Honor.
All right, ladies and gentlemen, this is the end of your service, but I'm going to have you all wait for me in the jury room and I come and speak with you briefly.
Judge, can they stand?
Sure,
Okay.
yes.
Would you like them to stay where they're?
They can stay there. They can come forward. I think there is.
Kind and loving young man who had a bright future ahead of him. Avante was always full of energy and laughter, and his smile lit up every room that he walked into. He was my sister's only son. He was my niece's only brother. He was the father of 2 beautiful boys, one on the way and the other one who he kept to him by his side. Since Avante's death, our family has been living a perpetual nightmare. My sister has trouble sleeping, eating, concentrating, and just getting along with the mundane task of everyday living. We all have nightmares and flashbacks of the day we went to the hospital to find out he was murdered. I walked into the room where he was being kept. I saw the tubes. I saw the blood stains. I saw the little boy who used to crawl into my lap and give me his toothy smile. But his smile was not there. It was gone. All our smiles have been gone since that day. My sister and my brother, Avante's mother and father, have been dealing with depression and post-traumatic stress disorder since this murder. She has been seeing a therapist to cope with her grief and trauma, but how can you alleviate that kind of pain? How can you fill a hole that can never be filled again? My family's lives have been shattered by this devastating loss. None of us will ever be the same. We will never see Avante smile again.
See you, sexy. Thanks for being here today, Maxie.
We'll never hear his laughter again. We will never see him realize his promise or God's given purpose. Avante will always be in our hearts and our memories, and I love Avante. And this court has brought justice for our family, and I am so thankful for each and one of the jurors with their service. And I am so thankful and I appreciate you all working tirelessly. So that's all I want to say for now, because I'm getting a little bit of shakiness coming on. So that's all I want to say, family. I love y'all, and justice has been served. March 31st, 2022 is the worst day of my life. My heart was broken. Looked everywhere, still in the sky. I was still look for him. Yeah, hug you. Hit me.
Okay, I can't hear that. So, obviously, impact statements, but the guy got 60-60 in life. So, wow. Like, wow. Okay. I think the defense was so. I think the defense were really, like, thinking that they would never get life, wouldn't get a conviction. Got 60-60 life. Life for murder, 60 for something, and 60 for something. So basically, 120 plus life, whatever life is. So he's 57, so yeah, he's gone. Did you say number before life? He had life for murder, 64, whatever it was, tampering with evidence, and 64, whatever else it was. I don't remember now. Three. I only remember the first count, murder. So yeah, we don't know if it could be concurrent or, you know, it'd probably be concurrent because he's 57. I mean, he's not going to see. He's not going to see the real world again. At least, Jesus. Okay, it's now 10 to midnight. With that, I think we're getting the stream. Thank you for most of you that stuck with me today. Even Nunya managed to stick with us today. She only slept about 20 million times, but she did well today. Thank you to Emma as well for sticking with us. I'm not sure who else is still around, but thank you to everybody. I probably going to do some videos tomorrow. I probably won't stream tomorrow. I think I'm streaming Saturday, so I got Mighty Meat on Saturday, so he's with me, and obviously Dr. Hines and talk with Sally and Matt. So yeah, do me a favour, chill. Don't worry, and just I will. I stay every day. Bite me, bite you on the arse. So yeah, I will be making videos tomorrow, but the other reason is that we got Tyler in tomorrow to do the bathroom floor, so he'll be there most of the day. So I'll probably have to do some work with him tomorrow. So yeah, so there we are. Not sure what we'll do next week, but we'll figure that out on the weekend. So yeah, Saturday. Remember, Mighty Meat. Is it Mighty Meat on with us for Matt Moore, which will be on for a couple of hours. I decided to do Matt Moore a bit differently, to do like 2-3 hour streams, because I think when we do like 6-7 hours, it's getting too much. So every Saturday it takes longer, but I think it's more beneficial. So yeah, with that, guys, thank you very much as always. Love you all to bits, and as always, let's finish with a free Zachary Anderson. And with that, take care, guys.